flashing. Can you
Yeah,
hear?
I can hear you. Can you hear me, Judge?
I can hear you, but we're not seeing. Okay, I think you're coming in now as a video. All right, so I can see
No,
Mr.
I'm live here.
And who is that? Okay, I don't hear. All right, Mr. Abney, and I understand Mr. Workin is arguing, but
Yeah, we can hear Mr. Workin, but I don't think he can hear
That's
us.
the microphone to mute me.
okay, are we working to get Mr. Workin so he can hear us? Or what?
MacBook Pro speakers.
Lena,
In the
are you
court.
there?
I believe I can hear you now.
All right, and we can hear you. Thank you.
Am I too loud, Judge?
No, not at all.
Okay, thank you.
All right, I think it is the day for it. And thankfully we have you in the same place at the same time. And Mr. Abney, we're going to go in the normal process. Mr. Abney just had an oral argument where we had to do a little more back and forth because of some challenges with technology. All right, so folks, I'm going to ask, make sure you keep your camera on during oral argument. I want to make sure that we can always see folks, and that way we can also be sure that we haven't lost you if you freeze up or something. Obviously, we are doing our oral argument in a virtual world, so I'll call the case and explain things a little. It's the time set for oral argument in 1 CACV 20-0385 Scott D. Roman Catholic Church. Council, of course, we are in the video conference process. As far as the clock, we know that you cannot see a clock. You do 20 minutes for your argument total. You don't need to use it all. Feel free, if you don't need it, to turn it back to the court. But at the same time, if you do, you do 20 minutes. Please keep track of your own time. I am also keeping track of time, and we'll try and give you signposts of where you are at, usually starting around 10 minutes and 5 minutes. But if you have a question about where you stand as far as time, if you are going to reserve any time for rebuttal, we ask that you do that. And again, I can tell you where you're at when you stop your argument. We understand that this may be a little challenging if you have trouble. If something starts to get glitchy, is the term of art, I believe, let us know. We're going to do the same for you. And please keep in mind, we have read all the briefing. We have studied the record, and we have discussed the case at length in conference. So we are familiar with it. With that, counsel, you may proceed.
Okay. May it please the court, my name is David Abney, representing Cale Scott. This also may be a fairly short oral argument. Cale's step was working in an attic space area that was very cluttered, filled with debris and tubing and ductwork and all kinds of other things, and he didn't notice that that there was no support where he put his feet, and fell right through where there's an aperture for a fluorescent light fixture. Badly injured himself. And the question comes down to who had control over the premises. And we're not talking about control over the work. There was a case that my colleague across the aisle cited, the DeBush case from January of 2021, where the Arizona Supreme Court dealt with possible liability of a sublessee when someone fell through, I think it was a skylight. And it's one of these duty cases that we're dealing with duty here again, but the Supreme Court, Justice Gould somehow seems to get a hold of these cases. He said in paragraph 11 of the opinion, defendants only owe a duty to DeBush if they had legal control of the premises or exercised actual physical control over the premises. So what we're dealing with here is legal control over the premises. This is one of those rare cases I pray for, where a defendant actually says, I have legal control over the premises. And in paragraphs 4 and 5 of the answer, the defendants actually admitted it for a change. They say that the property where the plaintiff was injured is owned, occupied, maintained, and controlled solely by defendant. That's paragraph 4 of
But doesn't that
record
go on?
9.
Well, that's not really the entire paragraph.
Well, I can read the entire. There's 2 paragraphs, 4 and 5. Answering paragraphs 7 to 8. The property where plaintiff was injured is owned, occupied, maintained, and controlled solely by defendant Saint Simon and Jude Roman Catholic Cathedral of Phoenix, SSJ. All remaining allegations and all inferences to be drawn therefrom are hereby denied. But the second paragraph is even better for me, I think. Answering paragraphs 10 and 14, the property where plaintiff was injured is owned and operated solely by SSJ, and only that defendant owned the common law duty. That defendant owned, I assume they mean owed. That defendant owned the common law duties imposed on landowners by Arizona law. All remaining allegations are hereby denied. So
Okay.
that
And
is an admission of
that
ownership.
gets the facts here. And what we have is an attic crawl space or an attic space. An attic space that was ceded, in essence, control to the air conditioning company to do its work. Isn't that accurate? In other words, didn't they give control of that attic space to that company to do their work?
No, that's not accurate. I think that an accurate way to say it is that they shared control over that space. They admit in their answer twice that they owned it. They say exclusively. I think they shared control over that space and said, go ahead and do your work there. But that doesn't change their legal control of the space, as DeBusch would put it. The legal control remained with the church.
Would you agree that they did not control the work in any way?
Oh, yes, they did. They did not control the work at that specific point. They had participated a little bit at the start of the project to help clean some things out in the attic area, but they weren't controlling the work. The work was being done by the contractor. But what they did control were the premises, and that matters under DeBusch, and it matters under, if you go back to Welker, it matters a great deal.
But isn't DeBusch under a different, really, analysis than what we're looking at here? It was really a different issue and really a different section of the restatement that was involved.
Well, I think DeBusch's importance is that it reinforces the general principle, and the general principle that finds more specificity in Welker and in Robertson in cases that follow Welker. But the general principle is that landowner can be liable in 2 different ways, and we lose sight of that often. We get so focused on the right to control the work that we forget that there's a part A, and the part A is legal control over the premises themselves. And the landowner can be liable when the landowner has that legal control over the premises under cases such as Welker.
Counsel, does that mean the entire premises? Or because Welker says, if I'm quoting just a small phrase, but it says, retained control of the premises where the work is being performed. So that'd be the attic in above the breezeway, correct?
Right.
Well, how did they retain control over that particular part? What evidence shows that they retained any control? I know you quoted from the answer, but that, again, this legal control versus actual control, I don't know that. Well, isn't there always legal control? Doesn't a landowner have the right to control its property? So whether it does in fact is another question. I mean, I don't know what's up in my attic. I don't know. I mean, I don't know if most homeowners are remotely familiar with their attics. Maybe they are intimately familiar, but does that mean I control it if somebody comes to work on my attic?
It may mean that you have legal control over it. A lot of times when you get these relationships between landowner and a contractor, there will be specific contract language saying you have control of the premises during the course of the work, or words to that effect. We don't have anything in the record like that. But what we do have in the record in the answer is this very emphatic declaration by the church that we exclusively, solely is the word they use. Yeah, we solely controlled the property where this occurred. The church
As far as the evidence, isn't the evidence that's actually in the record that the maintenance manager, and I forget his name, actually directed all people at the church to stay out of that area and to not interfere at all? Isn't that the evidence we have?
I think that's reasonably fair. Reasonably fair inference is that was going on, and that's what you normally do with a contractor. You know, keep your people, get out of the way. You want the contractor to do the work, but that doesn't change your legal control under the bush.
Contract critical when we have the facts are they said stay out of the way. That's their area.
It matters as far as the facts that the jury would have to analyze as to really who's responsible for what happened in an apportioning fault. But that's stepping away from duty. That's really getting into standard of care and getting into the jury's duty of trying to figure out comparative fault in a situation like this. I mean, when you get right down to it, a jury's going to say, well, the worker's X% at fault, the contractor's X% at fault, the landowner's X% at fault, and away you go. And that's the way it's supposed to be.
I thought your point was that the duty sometimes is laid out in a contract.
It can be.
That contract here.
Sure.
Well, I don't have the facts that establish that factual equivalent of the contract, which is the church stepped back and left the contractor do it.
Well, and in a contract, of course, is part of the whole thing. You know, if we talk about duty, duty arises from contracts, from special relationships, from the common law, from regulations, statutes, and rules. There's all kinds of sources of duty. And whether the contract in this particular case qualified the duty is a question that's really not on the table in front of us right now. The question is, well, because you have control over the premises, and you actually admitted you have control, you're very emphatic about that, what are the consequences of that? You know, the Bush says it matters. Legal control matters, not just control over the work, but legal control of the premises, which takes us back to Welker, which is one of the more interesting cases you're ever going to run across. It's work on dirt, basically. They're working on dirt there, moving it around, and they fail to shore it up properly. And this poor guy gets suffocated when there's a collapse of the trench area where he's working. The court says, well, in this kind of situation, in general, there's not going to be liability, but when there's an exception to this non-liability rule, and it's when, and I want to make sure I get this right, that you get the non-liability. We've turned over safe premises to the independent contractor without hidden and or concealed defects, and that's a question of fact. Are these defects hidden or concealed? And not retain control of the premises where the work is being performed, either directly or through independent contractors. But here for a change, the church says we had control over the premises. But Welker goes on in language that's been replicated in Robertson and other cases, and it says, there is a duty owed to an independent contractor and to his employees to turn over a reasonably safe place to work or to give warnings of any dangers. So you got to turn over a reasonably placed safe to work, which didn't happen here. Or you've got to warn of any dangers, give warning of any dangers, and that didn't happen here.
And I mean, you could argue anytime someone gets hurt that the premises were not turned over safely, but that does not get you to the jury. So what is it that you say gets you past this and created a duty? And it seems like what you're arguing is a duty to warn of some unsafe condition.
There's two things, the two parts to this duty. Duty owed to the independent contractor's employees. One, to turn over reasonably safe place to work. Now, in Welker, they turned over dirt. I mean, that's about it's reasonably safe and reasonably unsafe. I mean, everybody dealing with construction knows you got to watch out for dirt. If you don't shore it up, somebody's going to die. But that's not what we have here. The duty is to turn over a reasonably safe place to work. They didn't do that. The church did not turn over a reasonably safe place to work. They turned over a very dangerous place to work. Or, and the second part you were talking about, to give warnings of any dangers is the language in Welker. Warnings of any dangers, and they didn't, as far as the record shows, give a warning of any dangers to this independent contractor. So under Welker, there is the duty.
So there's a duty, you're saying, to not let anybody go in your attic unless you go up and we're talking about an experienced entity that understands working in an attic, has actually worked in this attic, and is familiar with the fact that there's no flooring. In fact, is in the process of putting plywood up because it knows there's no flooring. And you're saying that somehow, under all circumstances, I don't see how we'd ever be able to say letting someone go in the attic, no matter how experienced they were, hasn't created a potential dangerous situation.
Well, there may be a potentially dangerous situation, but when you look at it that way, you're drifting away from the duty. Welker says there's a duty here. If you don't turn over premises that are reasonably safe, and you don't give warnings, or you don't give warnings about that.
How do we decide? How do we decide that?
Well, from the facts, I mean, and it may involve a proceeding at the Superior Court if somebody wants to throw in some more facts, but they didn't throw any facts here that would negate duty in any way. What we have is turning over unsafe premises and not giving any warnings, and that's as far as we can tell from the record what happened. Now, if on remand, knock on wood, that happens, it'll be time to develop that if the other side wants to try to develop that. But when you get around, I think there's some discomfort, judicial discomfort in these kinds of cases. You see it over and over again, and it really is an open and obvious kind of defense discomfort. That, well, you should have known. You're a worker. You should have known. You were putting some plywood on in various places to put a flooring in the attic. You should have known about this. Well, that's really comparative fault. As a worker, you should have been better prepared for what you were doing. Or as a contractor, you should have told your employees, you should have protected them better. But that's all comparative fault. What we're talking about here is we're at step A. We're not even up to step B, C, or D. We're simply talking about duty. And under Welker, there is a duty here in this kind of situation. I think it would be a bit.
But how do we deal with Lee then? The case with the refrigerators and the cyberboard.
Well, I'm not sure that at that stage that the landowner had actual possession of the premises in a legal sense or otherwise. It was initial, they were still doing work to get this place open, but it was this poor clod, and it's hard to describe. There's some sort of very weak system connecting these areas above the refrigerator, some sort of almost like cardboard or something, and he steps right onto it. I mean, it's like, this is beyond belief. And I think that
aren't there some who would go, it's beyond belief that someone who's familiar with working in an attic would step off the joist?
Well, for the open and not,
didn't have a floor in its attic. As a child, I'm pretty familiar with you keep your feet on the joist.
Well, for an open and obvious defense, no. But this is not the kind of danger that was very apparent in the Lee case. This is something that is hidden and concealed. You can't see the forest for the trees for all the ductwork, the debris, the insulation, everything else is going on there. And without a specific warning to him, and there's nothing in the record about that, then there's going to be a duty. Now, Lee,
I apologize, but you're at 4.5 minutes.
Okay.
I didn't catch it.
Yeah, and Lee itself, by the way, said that Welker's still good law. So we're still confronted with the Welker issue here, and it's not just good law because the Court of Appeals has relied on it in the past. It's also good law because cases such as Robertson have specifically relied on it. The security guard who gets no warning of any kind from the people running the property, that there is an armed intruder on the premises, dangerous intruder on the premises, and as a result, he turns his back on this fellow that he encounters and gets shot for his trouble and dies. But the court in Robertson is very specific and quotes Welker, and actually quotes that language that I was quoting to you about the duty owed to an independent contractor and its employees to turn over a reasonably safe place to work or to give warnings of the dangers. Now, if you're a homeowner, apparently you can satisfy Welker by giving a warning of the danger to the independent contractor, the employees. You say, watch out, I've got the world's worst attic.
I mean, it is so unsafe. I never go up there, and if you go up there, be on your guard.
And Mr. Abney, this is Judge Weinswag, and we're not to consider the plaintiff's profession or line of inquiry, line of work, meaning, excuse me, whether he's up in attics every day and might have a better or a good understanding of what to look for. Is that relevant to the inquiry?
Not at the duty stage. It may matter a great deal for the open and obvious defense, comparative fault. You may get one of these crushing verdicts where you get massive damages and you get 95% fault given to the worker. It may be that disappointing situation, but for duty, no.
But open. So you're saying it's like a professional, open and obvious, because that's what I'm talking about. We have a professional. Let's say we have a professional day-to-day works in attics, and a homeowner who has something, plywood that's broken and might not necessarily understand that. You're saying that the homeowner owes a duty to this professional who spends each and every day in attics.
If you know that there's a problem with your attic, that it's unreasonably dangerous, and you don't say, yeah, you may have that kind of duty, certainly. The open and obvious defense is a very strange sort of thing. It actually has two parts to it. And there's a comment F to the restatement section. I can't remember the number of the restatement section, but and the comment talks about, well, you can have workers that are distracted, which certainly would apply here. And so the open and obvious defense really wouldn't work. Or you can have workers who have to do the work because if they don't do the work, they're not going to get paid. And so they're willing to confront that. And so the open and obvious defense doesn't apply where there's a distraction or an economic stranglehold where you got to do the work. But the open and obvious defense thing is something, it's step B, C, or D. It's not step A. Step A is simply the duty. And under Welker, under Robertson, there's a duty. And Welker's still good law. And that's my basic presentation.
All right, you have a minute left.
Thank you, Your Honor.
Thank you. Counsel, give me just a moment. All right, whenever you're ready.
Thank you, Your Honor. And may it please the court, I am Chaz Workin. I represent the appellees, both the church that owns the property and the diocese of which the church is a part, but the diocese is not an owner of the property. I'll begin where, and I forgot to start my stopwatch. Now it's running.
30 seconds, so you're good.
I hope not to use 20 minutes. And I should begin by apologizing for the technical snafu at the beginning. We were waiting in the room at quarter till, but we weren't recognized in the room. So, my bad. I'll begin where Mr. Abney began and placed his emphasis, and that is with regard to whether the church retained possession or control. And I believe we have to focus on possession or control of the work area. And frankly, plaintiff misconstrues the church's answer, which I think the court recognizes. The church in its answer was merely distinguishing itself from the diocese as the owner. The church, as I said, is the owner, the diocese is not. And the answer then went on to expressly deny any inferences. It wasn't admitting to any kind of control at the time that we need to focus on, which was the time that this worker, Mr. Scott, was up in the attic. I submit that retaining control of the premises as an owner naturally does, and to the extent which this church did, without having control of the work, does not create an exception to the general rule of non-liability to an employee of an independent contractor. So this case is much like Lee, in that Walmart was argued to still have control of the premises, although the Walmart or Sam's Club was still under construction, it was in the process of being cleaned up. Well, the church, like Walmart, had possession or control of other parts of the whole church premises. But at the time that the workers were up in the attic, it was not exercising any actual control over that portion of the premises. I would like to call your attention to an authority that I think all of us have overlooked. Perhaps the court in its research has seen it. In the Restatement of Torts 422, at comment C, there is this sentence: possession is usually surrendered fully in the case of construction or demolition work, and it may be so surrendered in cases of extensive repair. I think that's what we have here.
Which restatement was that?
It is section of Restatement of Torts, Your Honor.
No,
Section,
second?
Second, of course.
So what is curaz? Does curaz say anything about the restatement second as a source or informing duty?
I didn't hear the first part of your question, Your Honor. Does what say?
Another curaz. I don't have this. Keep going. I'll find a citation for you.
Okay.
Well, I guess let me try and follow up on that though. Has Arizona adopted the restatement second of torts, in particular this section regarding duty?
I believe that there are a number of cases that have discussed 422, several that have, including, I believe, Welker, that have found it not applicable to an employee of an independent contractor under the circumstances of those particular cases. But I think the key here is that comment makes clear that even though an owner has possession of the entire premises, they surrender possession when there is, construction going on. Here we have, I think, what you could call demolition, or at least extensive repair, because the idea here was that Apex, the contractor, was going to remove the old HVAC system and replace it with new. So I think that comment is very apt here. And
can you address just the idea that the owner of premises can cede part but not all of the premises as far as the control?
Yes.
But is there any case that's actually said that nice and square on?
I don't know of any. I think that this comment alludes to that when saying that possession is usually surrendered fully, but that suggests that possession or control can be surrendered partially. That's what we have here. The church didn't surrender control of the altar, of the pews in the church, but the attic is something else. And
it was just part of the attic.
It was only part of the attic, yes. And it was that part of the attic that there was nothing stored up there. And so the church's people didn't go up there in advance of the work to remove those things. The Christmas decorations and what have you were admittedly in a separate part of the attic. So, which brings me to the point that I was going to get to in a moment, that under 343, one of the first conditions to there being a duty is whether the landowner was aware of the dangerous condition. And here, there's not only evidence that there was no such awareness, but it is undisputed that the church did not have notice of a dangerous condition.
Mr. Workin, on 343, I'm glad you brought that up, but because it also says a landowner is potentially subject to liability if the landowner knows or by the exercise of reasonable care would discover the condition, that harmful condition. So, well, that starts to cry out for some sort of fact issue, does it not? How do you evaluate what's my duty as a landowner to go inspect the property around my house, up in the attic, make sure there's no rattlesnakes in the crawl space underneath. I don't know. What, help me out. Help me understand that.
Well, I think that the words you were reading, and I'll get them in front of me to be accurate, should realize, well, should one expect, and I think this in a way goes to the other two, or at least one of the other two conditions under 343, is it reasonable to expect the church to send somebody up in the attic on a recon mission to see if there's any dangerous condition there? I would submit to that the duty or the responsibility doesn't go that far. I don't want to use the word duty in that sense, but the responsibility doesn't go that far. Now, 343 imposes three conditions, and unless all three of them are satisfied, there is no duty. And we're talking about 343 just as plaintiff did in its brief, and in relying on it to impose a duty on the landowner as to the employee of an independent contractor. So we're not talking here a case where you have a business invitee in the nature of a patron of a business, or for that matter, a member of the congregation that came to the church to worship. Of course, they wouldn't be going up to the attic. So there's a distinction to be made between business patrons and employees of independent contractors who come to the site to do work in a place that isn't open to the public.
So just to follow up on that, so you're saying if there were a pew in the chapel that it was weak, the wood was weak, and it looked like it could break, and then a patron actually sits down and breaks and is injured, that would be more akin to like a reasonable inspection would have revealed that, and that's a different question than what we're looking at here.
Absolutely. Your common premises liability slip and fall cases often turn on whether the store operator knew that there was a spill in aisle 13. Well, you could have your hypothetical, though, is closer to a physical condition that something's broken or deteriorated as opposed to a spill on the floor. But yeah, if you know about it, or you should know about it, that's going to contribute to the satisfaction of these elements, or these conditions rather, to duty under 343.
Let me ask you, because you said identified there are three conditions. Do you concede that Mr. Abney's client has satisfied any of the three conditions, or are you saying they don't satisfy any?
I argue that they have not satisfied any, that the facts that are undisputed.
Let's talk about each and tell me why they didn't satisfy them.
Okay. Well, first of all, in the statement of facts, there is the statement that there's no evidence that the church knew that the light fixture was a dangerous condition. And that isn't disputed. And on top of that, you have the fact that the church didn't enter the relevant portion of the attic space before the work. The second condition begs the question of, should the church have expected that Scott, the plaintiff, either would not discover the condition or would fail to protect himself? Well, there's no reasonable juror that would conclude that the church should expect that an experienced HVAC technician would not realize the danger of an attic space that had no flooring and that he only had joists to step on. And no juror would expect that Scott would fail to protect himself. That attic without a floor is an obvious danger. And certainly a licensed contractor, an HVAC contractor in particular, would appreciate it. And in fact, they did, which is why they were setting about to install the flooring when he took a misstep and fell.
Let me ask, the absence of the floor that's the dangerous condition, light, no light, whatever, stepping off a joist in a place with no floor is a danger, no matter where you're.
Yeah, if, I think naturally there's drywall underneath, and it's not weight bearing. So you step on the joists, which are supported on either end by the walls.
And so no matter what was going on with the light fixture, the bottom line is he went into an attic with no floor and knew to stay on the joists.
Yes, and
That's all. We don't need to worry about the analogy to a light, a skylight on a roof. It's not that. You keep your feet on the joists.
Right. And the third condition under 343 is whether the church failed to exercise reasonable care to protect Scott. Well, Apex came along and relieved the church of any responsibility to protect Scott because the Apex realized the nature of the attic and the need to put down flooring and was in the process of doing so. So to answer your question again, no, I don't concede that any of those three conditions are satisfied. In fact, none of them are, but if only one of them is not satisfied, there's no duty to the employee of an independent contractor.
That was going to be my next question, so thank you.
Yes. So, I think we've talked about control. I think we've talked about the elements necessary to finding a duty to this type of visitor on the premises.
And you have 6 minutes left, so you know.
Thank you. My clock is still running. So what I would say perhaps in closing is that it is not an absolute that an owner has a duty to provide a reasonably safe place to work to an employee of an independent contractor. Any duty of a property owner to such a person is different from the duty owed to a patron of a business on those premises. And I suggest to you that the Lee case, the Fort Lowell case, the Kepke case, and the Rouse case from Federal District Court all support that. And the reason that there's a difference is because in this situation, when you're dealing with an employee of an independent contractor as opposed to a patron, you have to go to 343 and you have to analyze and apply each of those conditions. So unless the court has other questions, perhaps I would make one clarification of the record. There's talk about how cluttered and debris-ridden this attic was, but the allegation that it was denied, and Mr. Scott's statement doesn't say that the fixture was obscured. He only says that he did not see it. He says that it blended in very well. But again, here he is, a professional who is up in the attic, tiptoeing on the joist, and should know that whatever lies between them isn't going to support his weight. So again, if the court has other questions, I'd be happy to try to answer them.
I'm not seeing any.
I was hoping that Judge Weinsflag would find whatever it was he was hoping to find. Can't hear you.
It looks like the answer is no.
Okay.
All right, so give me just a moment.
Yes, and I thank the court for your time and
Mr.
attention.
Abney, and, you have 3 minutes, Mr. Abney.
Thank you, Your Honor. I doubt I will need it, but you never know. Welker's pretty clear in what it says about, and in fact it says must be clearly understood that the rule of non-liability is this. The contractee turned over safe premises to the independent contractor. And there's an amplification of what you mean by safe premises without hidden and or concealed defects. And here I submit to you that reasonable jurists could say, well, the defects here were hidden or concealed. Whether you call it blending in to the general mess up there or covered with other junk, I don't think that would matter a whole lot as far as whether it's hidden and or concealed. And that the contractor has not retained control of the premises where the work is being performed. And here we have two specific paragraphs in the answer that say that they solely control the premises. We keep coming back to comparative fault. My colleague across the aisle says no reasonable juror would expect that Scott was unable to protect himself. Well, why not? Say that a reasonable juror could say, naturally, given the conditions in an attic crawl space area where there's junk all over the place, you could be distracted. You could be concentrating on your work and not realize that you're putting your foot where you're not supposed to put your foot. It would be up to the jury to decide, well, is a ceiling strong enough to take a little bit of weight if you accidentally misstep on it? Or if you've got an aperture where there is nothing there but the light fixture and you step on that, that's certainly a hidden and concealed danger that's going to be fatal in certain conditions. I think that really I've made my pitch as well as I could. I do admire the DeBush case. I was on a program recently with Justice Gould, was one of the members, and we talked at length about DeBush, and so I looked at it very carefully after that, and it brings a lot of clarity to these sort of premises liability cases when you say you owe a duty if you have legal control of the premises or exercise actual or physical control over it. So I think that the church had legal control. This is a hidden, dangerous condition, and there is a duty of care.
Thank you.
Thank you, Your Honor.
For your argument. We appreciate it. We appreciate the briefing. We will take the matter under advisement and issue our decision in due course.
Thank you, Your Honor. Appreciate it.